Hey, we got some of these email type questions. My dad's home was foreclosed, and I never knew about the surplus money from the sale. So there was a surplusage until now. Well, we don't tell us when it was foreclosed. Was this 20 years ago? Anyway, who do I contact about the sale proceeds? Whom do I ask? Who sold my father's house and when? Who do I ask about the proceeds? Well, here's the deal. When if it was foreclosed on, then probably a non-judicial sale, all that. But all of that would be public record. All of that you just go to the county where your dad lived, right? Go to that county and find out. Well, uh, where was the house? You look it up. You get the records to find out all the information on the sheriff's sale. Now, if there was an overage, if there was extra cash in the sale after the payment of the foreclosure, then yeah, you're entitled to get that. You're entitled to get that money back. Well, how would you get that money back? Where's the money now? Let's assume that it's been a couple of years, and so what would happen is if there's money hanging around, and I'm guessing Dad's died. It doesn't say that. I'm just kind of guessing, but because you expect our email writer here expects to get the money themselves. So what I'm assuming is that dad has died and the money didn't go into. If he's gone, then you'll probably need to open an estate, right, to go claim it. And it depends too on how much money there is. If it's more than around 25,000, you're definitely going to have to open the estate because probably what happened with the money was that it went to the state under its cheat, and now it's in the unclaimed property. That's where that would have been unclaimed property. And there's an 800 number. You can look it up on the website. Every state has this where you can go and say, hey, and then put your dad's name in, do the search, and say, okay, here's money that dad was owed, right? And they didn't know where to find him, or he had died, or whatever else. And that should all be in the unclaimed property. So what you want to do first is you want to go back to the county where dad lived, right? Um, get the legal description, and you may have to do some digging to do that, and you should hire an attorney, of course, to do that for you. Um, but once you've done that, once you've found out where, then it should all be recorded there. How much extra there was, who eventually bought it, that kind of thing. At the very least, you find out who the creditor was, and you track that down. And if there was extra money, then it probably is cheated to the state. The state of Michigan probably has it in the unclaimed property fund. So that's what you ought to do right there. Can an assignment of interest in property of a state be contested or revoked? Well, this is a little bit interesting. So here's the thing. I was appointed independent administrator of parents' estate, personal representative. That no will, sibling and I are only heirs. In exchange for taking care of my parents, sibling promised I could keep all the interest in the home. Early on in probate, sibling made good, signed an assignment of interest on property of estate. They assigned any and all interest in the property, claim to the estate, have not taken possession or interest in the property, have not disclaimed the property. Okay, so they're saying, yeah, it's my property, and I hereby irrevocably send it over to you. Okay, now they're unhappy. There's a leftovers in the estate. So the question is, what do we do now? And the sibling won't sign off. Now, I've said this before. I think whenever you're dealing with it, whether it's trust administration, probate administration, anything at all, signing we call them a receipt and release, saying I got my property, I'm happy with it, and I'll never sue you, right? That kind of idea. I accept the accounting of the estate, and everything was just wonderful. That's what you want every beneficiary to sign off on. Now you're in probate already. Already you're in probate. Now, when we're doing these with the trusts, of course, there is no probate because number one, our trusts were funded. The assets are actually in the trust, so I don't have to go to probate anyway, unlike most trusts where you do have to go to probate because you didn't put all the stuff in the trust. Anyway, so we don't have to go to court. And to go to court and resolve a situation like this is a pain in the butt. So we keep the trust administration open until the beneficiary finally says, yeah, fine, I'll sign off on it. If it goes too long and, they're really obstreperous and disagreeable and what have you, then sometimes we will go to court and we'll do an action to just to settle the estate. Because if someone's complaining now and they're not willing to sign off, right? Then they're going to just complain later on. You're just pushing it down eventually you're going to wind up in court anyway. Right? It's a judgment call because sometimes people are all bluster and no follow through. And so sure, we've had those. And then, you just resolve, even if they don't sign off, we'll distribute it. But that's a judgment call that we don't make, that the trustee makes, right? So we've got a situation where someone's unhappy that they signed over the house. They did sign it over. They said, yeah, it's all yours because you took care of mom and dad. And now they regret the decision. Very common. It's not very common? Getting them to sign off on it. That was that was an excellent move and not usually done. Usually these emails, the way these things go is they said I could have it, but now they say I can't. What do I do now? And the answer is you're screwed. Well, what you did was early on, this person, what they did early on was they got them to sign off. Good. And now they won't sign off on the final settlement. Well, you need them to sign off on the final settlement. Otherwise, it'll come back, or it may come back. I'm not guaranteed, but it may come back, and now you get more expenses, all the rest. So it's always a good idea with a situation like this where you've got people, who might come back on you, beat them to the punch. Go ahead, have the hearing, right? Ask the judge to pass on the accounts. And at that point, your sibling will come forward with whatever complaint it is they've got. And if they don't come forward with a complaint at this time, they're done with it. It's over and out. Forget about it. You're done. And these things are very difficult to unwind. We have a lot of people. And what I would have done here is a deed. We've done it as a deed. And the fact that there was no deed here, that's the one thing that makes me wonder, jeepers, maybe you get a sympathetic judge for whatever reason who decides, oh, you shouldn't have done it. So that's a possibility. Once you have a deed, they don't go back and look at those. That's a done deal. And I would say that in a situation like this, that most probate judges, my familiarity they'd enforce it, because that's why you do these things. So they're enforceable, because everybody knows that people change their mind. Now, without a deed, you might get somebody who, gets soft-hearted about it. I don't know, who second guesses it. That's a possibility, but not likely. Not likely. I mean, judges want to resolve real issues. Okay, generally speaking, that's why they became judges, because they want to fix problems. And if people already fixed the problem, and then somebody tries to break it again, they don't like that. You got an issue, you got a problem or something. Good, that life happens. Let's fix it. But if you already fixed it and then you break it again, I don't know very many judges who are like, oh yeah, let's trash everything 5 times so that we can fix it a million times. They are busy. They got other things to do. They got real issues. And the law has been like that, right along. Where, one of the principles in judicial economy is, if you had a chance to fix it, you should have taken your chance. If you did fix it, we're not going to revisit it. So I think this is very solid. And but I would bring the final accounting to the court and just have the judge's blessing on it.